guys, it's Kathy. I hope you're doing well. We're going to continue with Nope. No, we're not. We're going to continue with OJ. Yes, we are. So, I'm pretty sure we're here on number 20. So, we're still in the preliminary hearing. We're on part 6, I think. And then, if we can get 2 done today. Oh, this next one's only 4 minutes long. We can do 3 today. We can start July 7th. Yes, sir. All right, let's just jump right in.
June 13th. Yes, I was.
All right. Could you tell us what time you received the call to report to those premises?
I received a call at approximately 5:30 in the morning.
All right. And how long did it take you to get to the premises at Rockingham?
I arrived at the scene at approximately 7:10 that morning.
All right. Now, had you previously been to any other crime scene that morning?
No.
So actually, the first scene you were called to on June 13th was Mr. Simpson's residence at Rockingham. Is that correct?
Yes.
Did you later go to visit the premises on Bundy?
Yes, I did.
That was after you had completed your work at the premises at Rockingham. Is that correct?
The entire scene at Rockingham was not completed before I went to Bundy.
I see. So there was continuing criminalist activity going on at Rockingham at the time you left to go to Bundy?
No.
Maybe we'll get 30 viewers this time. 30. I'm up to, I think it's 13 or 16 cents I get paid each. Oh no, I get half of that. I get half of 13 to 16 cents every OJ video I play.
I completed the outdoor portion of the crime scene at Rockingham and then proceeded on to the Bundy location.
All right. How long were you on the premises at Rockingham before you left?
Roughly 3 hours.
And
no, Fozzie, real
the
ones.
activity in which you were engaged included the collection of swatches in order to examine stains, red stains, is that correct?
Yes, that's part of the collection, yes.
All right. And did you also recover a glove from the area to the south of the residence?
Yes.
Now, as a criminalist, are you aware of any test that can be done at the scene to ascertain whether a particular stain...
Is it just me, or like no matter how distracted we get while this is playing, every time we hear glove, every time I hear glove, I'm like, whoop, what's going on? I don't know why. He just said glove, and I was like super focused. Oh, Rebecca, thank you.
is human blood.
Objection, irrelevant.
Over.
We do not do human blood tests in our department at the scene.
Where are those tests conducted?
That is done back at the laboratory by the serology unit.
And how long does it ordinarily take to accomplish one of those tests?
I've never worked in the serology unit, so I can't really give you a good estimation.
Were you aware of any such tests being completed with respect to any of the evidence you collected on the morning of June 13th?
Hi, Belle. When are you getting home?
Prior to 10:45 in the morning?
Could you repeat the question?
Were you aware of any such tests to determine the presence of human blood being conducted with respect to any of the evidence you collected on the premises at Rockingham Avenue on the morning of June 13th?
No, I was not.
Thank you, sir. Nothing further.
Ms. Clark?
Mr. Fung, what test did you perform on the bloodstains at 360 Rockingham Avenue?
I performed a presumptive test for blood using the reagents phenolphthalein and hydrogen peroxide.
And what, if any, result does that test give you with respect to stains that may or may not be blood?
That test is a presumptive test, meaning that it can eliminate a suspected stain of being blood, and it is a good indication, if it is positive, that the stain is blood.
And did you perform such tests at the request of Detective Van Adder at 360 Rockingham on the morning of June the 13th, 1994?
Yes, I did.
Did you do so with respect to a white Ford Bronco located there?
Yes.
And with respect to blood drops on a driveway located there?
Yes.
And with respect to a glove found at the south side of the property there?
Yes.
And your results were?
Those tests came back indicating the presence of blood.
Positive for blood?
Yes.
And did you indicate those results to Detective Van Adder?
Yes, I did.
Kelly, don't let those cats pick on you. Don't let them bully you. You're bigger than them.
I have nothing further.
Mr. Ullman?
I'm a little bit confused. Tell us again what a presumptive test tells you.
A presumptive test can eliminate whether a suspected stain is blood or not, and it is a good indication whether a stain is blood, but it is not a confirmation. It's not 100% infallible.
Okay, now I hope 300 come today.
In other words, other substances than blood may give you a positive reaction to this test.
There are a few substances reported in the literature that will give a false positive, yes.
All right. So when you say the test is positive for blood, you're not telling us that the test has indicated to you that the substance is in fact blood. Is that correct?
Objection, Your Honor, this is irrelevant. I went into this witness's, the result that he obtained in order to inquire into Detective Van Adder's state of mind and good faith belief that there was blood determined to be on the surfaces tested.
Hi, Kiki, my love.
The validity of the test, the reliability of the test is a matter for later testimony, I'm sure, and cross-examination would be appropriate at that time. At this point, we're inquiring into the officer's state of mind, and that's all.
Do you expect to go at length into this at this point?
No, Your Honor.
The objection's overruled.
The results of your presumptive test then were not, quote, positive for blood, were they?
They are an indication that blood may be present.
And you indicated that you performed a presumptive test of this nature on a Ford Bronco automobile?
Yes.
Now, was your examination limited to the exterior of the Ford Bronco?
On June 13th, it was.
All right. And how many stains on the Ford Bronco did you test?
I believe one or two. I don't
One
recall.
or two?
Yeah.
Could you check your records to see whether it was one or two?
It looks like those pages are blank. Oh no, I see something now.
My notes indicate that it was one.
Thank you, sir.
Ms. Clark, anything further?
One question, Your Honor, if I may. When you indicated that there were other substances that may test positive for blood that are not blood,
Yes.
what are those?
There are vegetable compounds that will give a false positive, and there are some other chemicals such as permanganate and dichromate that may also give a false
Watch your
positive.
mouth.
What are those chemicals?
They're
Let me ask you a different question, sir. Are those common household chemicals?
normally not, no.
Thank goodness.
Mr. Ullman, anything further?
Nothing further.
Thank you, Mr. Fung. You may step down. Please do not discuss your testimony with anyone.
Thank you, Your Honor.
Mr. Ullman, do you have additional evidence you intend to present with regard to the motion?
That completes our evidence for the motion.
Ms. Clark, do you wish to present some rebuttal evidence with regard to the motion?
No, Your Honor, the people are ready for argument.
All right.
We'd ask the court to receive the exhibits marked pursuant to this hearing.
Well, let's see. Now, the exhibits, I don't believe you marked any exhibits with regard to this hearing, although we do have A through H that have been marked by the defense. There was reference to other exhibits that have been marked with regard to the preliminary hearing itself.
Yes, nothing freshly marked. The court, I stand corrected. Thank you, Your Honor. I'd ask that they be admitted to the extent referred to by the people after this hearing as well, then.
And Mr. Ullman, are you moving for the receipt of the defense exhibits?
A through H, yes, Your Honor.
Or is there any objection to the receipt
Hope so.
of any of the defense exhibits?
Yes, there would be an objection to defendant's E. I still don't see the relevance of that. Those were notes taken by Detective Furman.
Either in 5 minutes ago, either I pissed everybody off or Fozzie logged out of 8 accounts. My numbers just dipped to 5 people.
With respect to the search warrant affidavit, again, Your Honor, people renew their objection. I think that the court had indicated it was not going to receive that. And with respect to G, defendant G, the 3 vehicle reports concerning the Bronco, those are hearsay. No adequate foundation was laid for their receipt, nor was any theory of relevance, I think, ever demonstrated by the defense to justify the receipt. And the rest are, with regard to all the photographs, the people have no objection.
All right, Mr. Ullman, do you wish to be heard with regard to E, G, and H? With regard to H, the court has already made a ruling. Unless you have something new to add, I think your record is clear that you felt that was admissible. That's the search warrant affidavit.
Yes, I believe there was a question that was permitted with respect to the representation in the affidavit that the trip was unexpected. So to that extent, we believe the affidavit itself is admissible. With respect to E, the relevance of those notes, of course, is that they abruptly end when the detective left the premises at Bundy, and to show that no contemporaneous record was made of any of the events that he was describing at the Rockingham premises. With respect to the vehicle impound reports, the reference to the coffee stains was contained in G2.
All right, with regard to...
G1 also indicates the time of the impound of the Bronco as being 7:30 in the morning.
all right, let me take them one at a time. The search warrant affidavit, the court doesn't feel that the grounds have been established to admit the entire affidavit, so the ruling stands as to that. With regard to Detective Furman's notes, apparently there was testimony that he didn't take any notes beyond the time that he left the first location, and therefore I don't feel that then makes what he did write down at the first location admissible. the fact that he didn't take additional notes is part of the record. So I don't think that E should come in. With regard to G, 1, 2, and 3, there was some testimony about a coffee stain and apparently some testimony about somebody from the media placing a coffee cup down on the Bronco and spilling it. But nonetheless, there was no foundation established for G, 1, 2, or 3 as to who made them, when they were made, and the accuracy of the information contained in them. In the absence of that foundation, and the people have raised that foundational objection, the items are hearsay. And so E, G, 1, 2, and 3, and H would not be received. Now,
I'm sure none of us here have any idea what you're talking about. Never.
with regard to the people's exhibits, you asked that they be admitted to the extent that they were utilized in the hearing on the motion, and my recollection with regard to that is that there were photos of the Bronco that were shown. I think with regard to the diagram, you mainly used the diagram that the defense prepared, and there were some photos of the driveway area and the house, and photos of the glove and that pathway area. I don't recall just off the top of my head which numbered exhibits, which people's numbered exhibits.
Cameras always pan away from where you want to see it the time you want to see it, Kelly. We will remember what you just said here when the camera pans back.
Those were.
Was the court asking for my assistance in that?
If you happen to have that information.
I do. I believe it's 6 and 8 and 9, but I can confirm that right now, Your Honor.
Okay.
That's right, 6, 8, and 9.
All right, and with reference to the motion then, Mr. Ullman, are you going to be speaking to the motion?
Yes.
The guy in the back row behind OJ's lawyers, A, B, or C, Kelly? Who are we looking at? A, B, or C?
All right. Does the defense have any objection to the receipt of People 6, 8, and 9 as it relates to the motion?
No objection.
All right, then those items would be received with regard to the motion. It is the people's burden to justify this since we're acting in the absence of a search warrant. Do you wish to be heard at this time, Ms. Clark?
Kardashian? Yeah. Yes, that's Kardashian.
Your Honor, although it is the people's burden, it is the defendant's motion, and as the moving party, I believe they are entitled to be heard first.
All right, Mr. Ullman, do you care to be heard at this time?
Yes, Your Honor. Your Honor, I think a good starting point for this motion is with the Fourth Amendment itself, because essentially that's what this motion is all about. It's about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, a right that shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. I think what we're confronting here is police officers who have the Fourth Amendment backwards, who believe in conducting the search first and then obtaining a warrant. It's important to put this into the context of the search of a private family home, where the case is uniformly recognized that the Fourth Amendment protection is the strongest and the discretion of the officers is the most limited. I don't believe there's any serious dispute at this point, although the prosecution did assert in their motion that the area of the premises at 360 North Rockingham were some sort of common entryway for multiple dwellers in the premises. I think the evidence quite clearly shows that the entire area behind the walls and fences of this home were within the area that is traditionally defined as the curtilage of a home. And as Oliver versus the United States made quite clear, at common law, the curtilage was the area to which extends the intimate activity associated with the sanctity of a man's home and the privacies of life, and therefore has been considered part of the home itself for Fourth Amendment purposes. So the courts have extended Fourth Amendment protection to the curtilage, and they have defined the curtilage, as did the common law, by reference to factors that determine whether an individual reasonably may expect that an area immediately adjacent to the home will remain private. Every iota of the testimony that you have heard confirms the reasonable expectation of Mr. Simpson that these premises would remain private, including the maintenance of electronically controlled gates and the surrounding of the entire perimeter by a wall 5.5 feet high and a fence that is even higher on the boundary between the premises and the neighboring residential premises. Now, there are some limited exceptions to the necessity of probable cause and a warrant before an entry is made into protected premises. And it does appear that the exception upon which the prosecution is placing most reliance is the exception for exigent circumstances or emergencies. It's important, of course, to note that the prosecution bears the burden of proving that they came within this exception with respect to the investigative activity that was conducted at the premises on the morning of June the 13th. The exception for emergencies or exigent circumstances is a very, very limited one. It is limited to situations in which there is an imminent threat, and the kind of entry it permits is limited by the threat that is presented. In this case, what is being urged is an extension of the emergency or exigent circumstances exception beyond any which has been ever recognized in any reported case in the courts of California or the federal courts, for that matter. If Your Honor examines each and every case relied upon by the prosecution in their response to this motion, you will discover that every one of these cases involves a search of the scene of a reported crime, where the police officers have information that a crime has actually been committed on the premises, or the premises are immediately adjacent to the scene of a reported crime. And none of these cases involve investigative activity not related to the exigency that justified the original entry. I can go through each of these cases, and Your Honor will discover that they are consistent in this respect. For example, People versus Wharton involved a victim who had been reported missing, and an entry to the home of the victim to seek the missing victim. And the officers found a dead body wrapped in plastic. And the issue was simply whether the officers, by exigent circumstances, were entitled to cut open the plastic wrapper to confirm the presence of the missing victim without a search warrant. In the Tamburino case cited by the prosecution, the police were responding to a radio call that a robbery and a victim was injured and bleeding on the premises that they entered. They found blood spots outside the building and on a walkway of the apartment, and a neighbor confirmed that an injured person was inside the apartment before the officers made entry. In the McDowell case, once again, we have a report of an actual crime taking place on the premises and an entry to investigate the circumstances. It's a typical hot pursuit situation where there was actually a blood trail from the murder to an adjacent house, and the officers were following that trail within 45 minutes of the discovery of a murder. In the Amaya case, again, the officers had a report of a shooting on the premises. They observed a pool of fresh blood in front of the apartment, a trail of blood to a laundry room where they found the body of a victim, and they then entered the apartment in which the fresh pool of blood was found. And finally, Bradford, a classic hot pursuit situation where the police were actually chasing the suspects engaged in a gun battle with them, and the court held they were thus entitled to enter the premises where the suspects had fled to. So these are the kinds of emergencies in which the courts have recognized exigent circumstances and permitted officers to dispense with the requirement of probable cause and the seeking of a warrant. Obviously, those don't come near to any of the circumstances that have been presented here. We are extending the exigent circumstance exception by a distance of about 2 miles and by a duration of about 6 hours. And that is a long, cold trail for exigent circumstances. Here we have officers coming to these premises at 5 o'clock in the morning, at least 6 hours after the murders that they were investigating had occurred, a distance of 2 miles away from the scene of those murders. The victim, one of the victims of those murders, had been identified at 1 o'clock that morning. And it appears that most of the delay from 1 o'clock until 5 o'clock in the morning was consumed simply in deciding what detectives were going to investigate this homicide. We are told that the four detectives who were most responsible for investigating the circumstances of this homicide all converged on the residence of Mr. Simpson simply for the purpose of informing him of the tragedy that had taken place at the Bundy location.
Thank you,
A
Jen.
purpose that could just as easily have been accomplished by the placing of a telephone call. The officers claim no exigency, no emergency, until they discover what Your Honor has seen as a 1/8 to 1/4 inch dried speck of substance on the door of an automobile, which could not even be confirmed as being blood after scientific investigation, a stain which was just as consistent with a dripping taco or a driver with hangnail as with any circumstances of murder, suicide, or bleeding victims on the premises. I think it's very important to bear in mind what the California Supreme Court said in the case of People versus Smith, that the belief upon which an officer acts must be the product of facts known to or observed by him, and not a fanciful attempt to rationalize silence into a justification for a warrantless entry. And that is precisely all that these officers encountered at the Rockingham premises. Silence. And from that silence, they have conjured up horrific visions of the need to jump over the wall and enter the premises. Circumstances which do not appear in any of their reports and do not appear in any written form until after the motion to suppress had been filed in this case and the testimony was presented in this hearing. Even more important is the scope of activity in which these officers engaged after their entry to the premises. Even if we concede, and we do not concede, but even if we did concede that there were exigent circumstances justifying a warrantless entry to the premises, again, the scope of their activity on those premises is limited by that exigency. And that is a purpose which could easily have been accomplished in 10 minutes or less to ascertain whether there were any murder victims or suicide victims or hostages or bleeding persons on the premises. Everything the officers encountered immediately after their entry to the premises confirmed that there was no such problem on the premises. Their mission essentially was accomplished prior to 6 o'clock in the morning. They had accomplished the notification of Mr. Simpson. They had made arrangements for the well-being of the children that were the subject of concern. They had ascertained or located no other victims or no reports of any other problems, with the one exception that actually came later, after their mission had been accomplished, of the report by Mr. Kalin of a thumping on the wall 7 hours before the officers were then engaged in investigative activity. And I think everything that happened from then on can only be described as investigative activity, the gathering of evidence of a crime, the precise activity that the Fourth Amendment commands officers obtain probable cause and a warrant before they engage in it. Again and again, we heard the detectives say, well, we didn't know what we had. We didn't know what had happened on these premises. Well, we know what they didn't have. They didn't have a search warrant. And if we were to carve out an exception to the Fourth Amendment for detectives who don't know what they have, in effect, we would turn the Fourth Amendment on its head. And we would say, the less you know, the more you can search. Now, I know, and Your Honor knows, that the pundits and the cynics who are following this case.
Could you imagine the magistrate here in this court just saying to him out of nowhere right now, I don't care. That's what that judge did. She was awesome.
Suggest that this case is too high profile a case for a motion to suppress to be granted. We do not share it.
This argument is improper, Your Honor.
I would ask you to confine yourself to the facts in this.
We do not share that cynicism, Your Honor. I think it's important for us to bear in mind that what is at issue here is the application of an exclusionary rule whose purpose is to teach.
Walter, I can't do the full OJ Simpson trial in one video because it's 498 videos long. So I have to break it down.
And what better vehicle do we have to teach the lesson that the Fourth Amendment is alive and well in Los Angeles? I would close with the words of Justice Brandeis in Olmsted versus the United States. Our government is the potent, the omnipresent teacher. For good or ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself and invites anarchy. Thank you.
Ms. Clark?
Thank you, Your Honor. Well, Mr. Ullman speaks very eloquently and with a great deal of passion in terms that are very graphic concerning the activities that transpired in the early morning hours of June the 13th. But none of the rhetoric and none of the fine quotations can change the facts as they existed on those early morning hours. He attempts to depict in very graphic terms the search or the activities that were conducted at the location of 360 Rockingham as though a Sherman tank were being driven through the backyard and being plowed in through the doors. In fact, nothing could be farther from the truth. In fact, all of the actions that were taken by the officers in this case were clearly very carefully confined to the stated purposes that they had given to us throughout these proceedings. And I'm going to point out exactly how logical and how consistent those actions are as they matched up with every single motivation they've testified to in this courtroom. Mr. Ullman pointed out that we may have created a new exception here for officers who, quote, don't know what they have. No, that's not a new exception, Your Honor. As a matter of fact, I'm sure the court is aware of the case of Mincy versus Arizona, in which the officers are permitted to enter a location for the limited victim or suspect search. In fact, that is exactly what occurred in this case. They did not enter with guns drawn, they did not enter with helicopters flying overhead or backup units or anything else. If they had suspected there was a suspect on the premises, if they had intended to go in to collect evidence, all of those things would have been done. The fact that they were not done is further evidence to the court that what they were concerned with was an emergency situation of multiple varieties. And as the cases are clear, and the people have cited them in the motion, the officers are not confined to one purpose. They can't be. This is a human situation. This is not a laboratory where you pursue one objective and come to a conclusion, then pursue another one and come to that. These things do not happen in discrete units of time. And try as one might, or one would like, to pin down the events into a sequential order that is neatly packaged, things do not happen that way. And that's what we heard the officers testifying to repeatedly, consistently. In fact, even the civilian witnesses testified in that manner. Cato Kalin, who was trying to explain, well, it happened this way, it happened that way. Well, we got one picture during the questioning on direct and another picture during the questioning on cross. On direct examination, you might have had the impression that the officers came straight to the door and immediately upon seeing Mr. Kalin heard that the defendant was in Chicago. On cross-examination, we heard, no, he's not sure about when that came out. The officers went to his door, he directed them to Arnell. One officer stayed with him. The others went to Arnell's room. He indicated that he then had a conversation with that detective during which he told him about the thumps on the wall. The officer asked him, did anything unusual occur last night? Again, consistent with all of his concerns about what had happened at the crime scene that might relate to the location of 360 Rockingham. During the course of that conversation, Cato Kalin indicates, yes, I told him about the thumps on the wall. I know I told that story twice. I also told some detective about what I thought was the defendant going to Chicago in the limousine, going to the airport in the limousine and going to Chicago. I think I only told that once, and I know I spoke to another detective in the bar area, and that may have been when that conversation happened and when that information came out. Because things are happening in a jumbled mess, and you have witnesses, especially a civilian witness, who is rousted out of bed in the midst of sleep, disoriented and frazzled, who's unsure of the sequence of events that have occurred at that moment. So things do not happen that discreetly, and for the officers as well. Things were happening all at once. Now, with respect to the factual circumstances as they actually transpired, first of all, at the point that the officers leave for 360 Rockingham, the bloody crime scene, what is in their minds is what they've just seen at 875 South Bundy. They've seen a bloody crime scene with bloody shoe prints leading away from the crime scene and blood drops alongside to the left of them leaving the crime scene. And that tells them that someone left the scene bleeding. Moreover, they've seen a brown leather glove at the feet of one of the victims. They know that children, small ones, have been taken away from the scene and placed in police custody because they don't know where to place those children. They don't know into whose custody to deliver those children. They also know of the celebrity status of the victim's husband, the children's father, who lives close by, so close by that he's the most logical person to go to. You want to get to someone quickly who can take care of those children, as quickly as you can. The celebrity status of the victim's ex-husband is important because we know about the stalkers. We know that these things are in an officer's mind, and reasonably so, because he has to be considering everything, every possibility that may occur. If he fails to take into account every possibility, then we justifiably are upset. Why didn't you think of that, officer? Why didn't you protect these people? That's your job. And he takes it seriously. These officers did so. They took every possibility seriously, including that. Now, at the point that they left the crime scene, they were going to make a notification to the defendant, and they were going to see what to do with his small children. That they would go to him first, who is the next of kin closest to the children, makes eminent sense. That they would go to him first because he is the nearest relative, only 2 miles away, I think was the testimony, also makes eminent sense, and expect to find him. Now, what happens when they arrive at the location, having all of those exigencies in mind, knowing that you have small children to take care for, knowing the kind of bloody scene that you've just left, and the relative and the ex-wife of a celebrity like this, who may be the victim of a stalker. All of these things are in their minds at the time that they go to the residence and just want to find Mr. Simpson. That's all they're looking to do. Assure themselves everything's all right, take care of the children, they'll be done. And as Detective Furman put it, had Mr. Simpson come to the door, it would have all been over. We would have left. But that didn't happen. That did not happen. And with all of that in mind, the officers go to 360 Rockingham and attempt to raise someone inside the house. They ring the intercom repeatedly and get no answer. Yet there are lights on. There are lights on downstairs. There's a light on upstairs. There are cars in the driveway. They contact Westech and find out that a maid should be there full time. And on a property of that size, it's probably not unreasonable to think that someone should be there full time looking over it. And yet they don't reach anyone. Then they finally get the house phone number, and they call that phone number. And there's no answer, once again. Now their concern has to mount. These are human beings, these detectives, and they know all the concerns are still pressing on them. No answer to the intercom, no answer to the house phone, and there's lights on, and there's cars in the driveway. They have to be concerned. Now a detective has indicated, I see the car in front of the house. It seems to be parked kind of hastily, and I see what I think is a spot of blood on the door handle. They've come from a bloody crime scene where someone left bleeding. They get to this location, they see a spot of blood. Your Honor, I don't care if it's a spot of blood as big as a dime or as big as a quarter. It's unusual to find blood on an otherwise clean car. And a car that's parked hastily, one that belongs to Mr. Simpson, as they've been able to determine, whose ex-wife has just been found dead in a bloody mess 2 miles away. You have to consider that all of these things are happening at once, and they're in these officers' minds. At that point, when they fail to reach anyone, and they get the information that Westech Security has no knowledge that Mr. Simpson is supposed to be away on travel, they get nobody to answer the phone, no one to answer the door, and yet there's indications there should be someone there with the blood on the door handle, they would have been derelict in duty. It is absolutely incumbent upon them to do something at that point to assure themselves that the people inside that house are safe and secure, that there is not something horribly amiss, because they've just come from a scene so gory that nothing could be more amiss than that. And the connection directly to the household of Mr. Simpson is absolutely clear. And if they were to stand outside and think about leaving, think about waiting until Mr. Simpson came home, while someone may have lain dying, bleeding in that location, we would justifiably be upset. We would justifiably call them derelict in their duty, and they could not do that. And so, without calling for backup, without calling for a helicopter, without bulletproof vests, without their guns drawn, they went over, they decided to enter the property. And the fact that they did none of those things I've just indicated to the court is another indication of how consistent their actions were with their stated motivation. If they were looking for a suspect, if they were looking to collect evidence that was of a crime, they would not have gone in that unprotected manner. Nor would they have gone simply walking on the grounds to go and knock on a guest door immediately when they get to the backyard area. In the cases cited by the people and referred to by defense counsel, and I'm sure the court has already read them, one very important distinguishing factor is that in those cases, the courts validated the warrantless entry into a residence, and in some case, a forced entry into that residence. These officers went in and they kicked down the doors. The minimal nature of the intrusion in this case is an important thing to bear in mind. Because far from Sherman tanks going in through that backyard or using battering rams on the doors, these officers simply went into a backyard and knocked on the door of a guest house, which is an entirely reasonable thing to do under the circumstances and totally consistent with their stated motivation.
I hate going to the mall and shopping, especially with 3 young girls who take you into store after store after store after store. No, nope. I'm so sick, I can't go, sorry.
If their motivation, in fact, Your Honor, had been nothing more than to go and find a way to place these children with a responsible adult, given the fact that they were left in police custody for all these hours at that point, their actions would have been reasonable, if only for that motivation. And yet there was so much more, as the court's aware. Now, it is important to bear in mind that these are unfolding events, and as each event occurs, the information gathered spurs further action. So rather than going and searching for evidence, fanning out on the grounds to go and start searching under cubby holes and under tables and inside cabinets, they go for the straightforward thing. They go straight to a guest house in search of someone who could assure them that either nothing was amiss and assist in the placement of the children, or confirm that something was indeed amiss with which they could offer their assistance. They went to the door of Cato Kalin. Mr. Kalin, as he indicated himself, was frazzled and disoriented. They don't know who he is. They don't know why, if he belongs there. He may be a suspect himself. It's truly the case. They don't know what they have. Is he a victim? Is he a suspect? They don't know. They just have to find out. And at that point, when they ask him, well, is there someone around here who can let us into the house and find out if the defendant is okay or where he might be, he directs them to Arnell. Now, while the other detectives then immediately go to Arnell. Another indication that they are trying to resolve a situation that they just don't know enough about. They know a bloody, gory scene. They know that. They know children in police custody for whom they have no immediate placement. They know that. But they do not know what has gone on. And they have to find out, and they have to do it soon. Because every indication thus far has been that someone could be bleeding or dying back there. They go to Arnell. The first thing they want to do is resolve, where is Mr. Simpson? That is the first thing to resolve, because Mr. Simpson can dictate what is done with the children. He goes to Arnell. They go to Arnell and talk to her. In the meantime, not knowing who Brian Kalin is, Detective Furman stays with him for officer safety. Now, while the other detectives go into the house with Arnell to find out, to locate Mr. Simpson, Cato Kalin is speaking to Detective Furman. Now, let me point out again, the actions are entirely consistent with the stated motivation. The officers don't say, well, if you don't let us in, we're going to go bash the door down. They don't go to bash the door down. And they don't, once they're inside the house with Arnell, make any attempt to search, other than to find out, first things first, let's make the phone call. They do the least intrusive thing they possibly can at every bend and turn. If what they were doing there was looking to perform a general exploratory search, if this was a pretextual search, excuse to search, then you would have seen them roaming through the house. That never happened. They went into the house with Arnell, went immediately with her to the phone. Here, make the call. Let's find him. And while they're doing that, as the events are unfolding, Detective Furman is speaking to Cato. Cato was telling him, yes, something unusual happened last night. I heard a thump on my wall. Well, that kind of matches up to the timing of what Detective Furman thinks may have happened, what may have happened over at the Bundy Drive location, and now he's got to think, well, maybe someone did fall down, collapse, and it is back there bleeding. It's a dark area back there, and hearing about 3 thumps on the wall is a very startling thing in the middle of the night. Detective Furman would have been, I think, dismissible for inaction had he not gone to investigate that. So we have yet another action that is spurred by the events. As I said, the events did not occur in discrete units of time. You had a situation with the unfolding nature of the information that was being received that demanded that further action be taken. But at every bend and turn, the action taken was confined to the information that motivated it. Now, there is no indication at any point, I think, that Arnell said the officers were rousting through the house and conducting an exploratory search, and the officers indicated they did not do so. At no point did she indicate that the officers twisted her arm or threatened her to get her to let them in the house and make the phone calls that they did. And in fact, it's very interesting that what she indicates is that she was allowed to go and get the children with A.C. Collins, and within, she said, I think the station was 4 miles away. And Detective Van Adder indicated that he's decided to secure the residence for a search warrant within minutes of their return with the children. So within a 10 to 15 minute period, you have the discovery by Detective Van Adder on the driveway of the blood drops that causes them to then determine to secure the residence, which is just about the time that Arnell gets back with the children and A.C. Collins. This again indicates that the timing of this is a fluid thing, but there are a lot of events occurring at once, all of which are imparting information to the officers on which they have to act. And they did, and they acted reasonably.
I made blue waffles once.
Now, once Detective Furman got the information from Cato concerning the thumps on the wall, I think it can't be disputed that it was incumbent upon him to go out and investigate the source of those thumps. But even when he did that, he did it in a manner that was consistent with the stated motivation of being in that place to begin with. Because he indicated that he walked down the path, he saw the glove, and yet he continued to walk down the path until he went all the way to the end of the property because he thought that was a location large enough and dark enough that could have hidden the body. He went back, all the way back there and looked, leaving the evidence behind him because the motivation of finding a victim that may need assistance or an injured party that may need assistance was the primary motivation. And although the courts have indicated in Baird and in Duncan that you may not determine that the primary motivation was the emergency, that the officers may have many motivations, one of which is legitimately the collection of evidence. Yet I think it's clear in this case that the primary motivation by all of the actions taken by these officers was indeed to preserve life and to act on an emergency that may have threatened the life and limb of some party. All of the actions taken by the officers is consistent with that motivation. And again, I would reiterate to the court, to test the validity of the assertion that they were there to preserve life and limb, the court need only ask it so. What if someone had been injured and lay bleeding near death somewhere on the grounds while they decided to go and seek a search warrant? Or simply when they failed to get a response to their ringing or phone calls, just leave? What would we have said? We would have said they were derelict. We would have said that they were incompetent. We would have said nothing good about the manner in which they fulfilled their duties because they would not have been fulfilling their duties. Instead, they did fulfill their duties. They happened upon evidence. It's clear that the evidence they happened upon was in an outside area, and it was in an area that Mr. Kalin had more control, or more access to, I should say, because that was outside the outer wall of his guest unit. I'm not indicating in that regard that Mr. Simpson did not indicate an expectation of privacy with the gates surrounding his property. But I am indicating that there is a lesser expectation of privacy with respect to an area outside the main house that is most adjacent to a guest unit occupied by someone other than the defendant, who is, no matter what he may consider himself, not a member of the family, who's been living there for only 6 months and freely invites friends in and out and performs duties around the house. He himself is exercising dominion and control over the area. And by indicating to the officer the thumps that he heard on the wall, has indicated a desire to have the origin of those thumps investigated. Now, the fact that the thumps occurred hours earlier is simply no excuse for not going to investigate what might have happened to cause them. I hope that counsel is not suggesting that a police officer is supposed to take a report from someone who indicates, well, yes, 3 hours ago I heard gunshots. So, well, 3 hours ago, forget it. Is an officer supposed to do that? Wouldn't that be ridiculous? Wouldn't that be horrifying if an officer did that? It doesn't matter if it was 7 minutes or 7 hours ago. An officer has a duty to investigate what may be a very serious situation that may be indeed life-threatening. And if it was 7 hours or 7 minutes ago, he is incumbent upon him to go and determine if something has happened to someone, because he may yet preserve life. And the officer did exactly what he should do under the circumstances. I would reiterate to the court the cases previously cited of People v. Saldoff, People v. Bradford, and Camberino v. Superior Court, all of which fully support the search that was conducted in this case. And in fact, counsel cited to McDowell as an example that was inapposite. I disagree. That case is very similar to the instant case. There were a couple of residences. The actual crime scene, I think, that they found was the Bradford residence. The DeCrenza residence had been searched by a previous officer and abandoned when Officer Petrosky, following a blood trail, followed it into and out of that residence.
He shouldn't be mad, Mel. If he wanted quiche, he can make quiche.
Leaving evidence there and continue to pursue the blood trail until he found the defendant. And only after securing the defendant went back without a warrant and collected the evidence. In this case, we don't have any of the problems of abandoning the area of search and coming back hours later without a warrant. Under his circumstances, it was very clear that by the time he went back to seize that evidence, there was no exigency, there was no...
You don't have to tell him he can make quiche if he wants quiche. He can just make quiche if he wants quiche.
Emergency. The defendant was under arrest. Everything was secured. He had ample time to go and get a search warrant. He certainly had probable cause. Did he do so in McDowell? No, he didn't. No, he didn't. He went and he saw all those items. He left. He went to do other things. He came back without a warrant and seized them. Certainly, People versus McDowell makes the search issue in this case look like there's no problem. There's nothing to talk about here. And People versus Amaya is the same. You have a situation where the officers go in, see evidence, leave, come back in, go get other officers, go back in again, over a period of hours, and never bother to get a warrant. That was not the case here. That was not the case. These officers went in with a stated emergency that was reasonable to believe existed. They acted in a manner consistent with that belief, happened upon evidence, and as soon as that evidence was found, stopped everything and got a warrant. Now, it is true that Detective Van Adder called for a criminalist to examine the blood on the exterior, on the door of the Bronco. But again, People versus Duncan makes it clear that there is not one purpose that an officer is restricted to, nor is the court required to find that the primary motivation of any officer is an emergency or an exigent circumstance, as long as that is one of those, as long as that is one of the motivations, and that motivation is reasonably held, that belief is reasonably held, then the search, the warrantless search, is valid. And in that regard, counsel has cited People versus Dixon that holds to the contrary. That's an appellate case. That case is disapproved in People versus Duncan, which is a California Supreme Court case that came later. And in that case, People versus Duncan, the court said, and I quote, "It is unreasonable to expect an officer to be unconcerned with the collection of evidence and the capture of criminals. While the trial court must find that the officer believed an emergency to exist, reasonable actions taken by the officer should not preclude such a finding. An officer who is acting reasonably under the circumstances in which he finds himself, as long as one of the purposes is justifiably that of emergency, and I think we cannot have any doubt that that existed here. The fact that he also intended to preserve and collect evidence, should it become relevant, certainly is no reason to find invalid the genuineness of his belief in the fact that an emergency existed. Just as the officer did in McDowell. When the officer in McDowell went running through the house, following the blood trail, he saw evidence there. He decided that it had to be preserved. He went out and got the defendant, called for a criminalist, and went back to make sure that it was preserved and photographed in place, never considering getting a warrant. In this case, especially with respect to the Ford Bronco, parked on a public street with a door handle, an exterior door handle that evidenced blood, Detective Van Adder thought, this may be needed to be collected. We may need this in the future. We may not. We may not. But a careful officer, an experienced officer, a dedicated officer knows that you can never tell what you may encounter. They did none of them suspect that they were at the residence of a suspect. If they had, do you think in a million years they would have gone over that wall without their guns drawn, without bulletproof vests, without a backup unit, without helicopters? Never in a million years. And that's why he indicated to you this was not a suspect's residence. We were concerned for the occupants, not for our safety. And every action they took makes it abundantly clear that that is precisely what they were doing. Accordingly, Your Honor, the court would urge, the people would urge this court to find that the search was reasonably undertaken for the legitimate purpose of preserving life, and additionally, Your Honor, that the car, the Ford Bronco, was in plain view, was seizable under the line of cases under Ross and its progeny, and that that does not constitute a search for which any warrant was required, especially as to the exterior door handle, which is the subject matter of this motion. And we would ask the court to admit the evidence seized prior to the issuance of the search warrant.
Mr. Allen, do you wish to be heard in response?
Very briefly, Your Honor. Four very brief points. First, if we simply take the officers at their word, that their purpose in going to these premises was to notify Mr. Simpson of the murder of his wife and to arrange for the care of his children, we're left with and conduct a search. But that, we're told, wouldn't in a million years have been their purpose. They were not looking for a suspect, we're told. Now, again, if we take the officers at their word, they said, if Mr. Simpson had come to the door, even after we climbed over the wall and knocked at the door, we would have left. Well, within minutes of that knock on the door, they had accomplished their purpose. The evidence is undisputed that the call was completed to speak to Mr. Simpson in Chicago shortly after 5:45 in the morning. The testimony of Officer Furman is that between 6:15 and 6:30, a half hour to 45 minutes later, is when he first engaged in his foray to explore the area to the south of the residence in the wall behind Mr. Kalin's room. Third, Ms. Clark has said, well, this case doesn't involve rousting. It doesn't involve Sherman tanks invading the premises. But, of course, that's not what the Fourth Amendment is designed to protect us against. It is designed to protect our reasonable expectations of privacy. It is designed to protect against the activity of police officers searching for evidence without probable cause and a warrant. And I don't think there can be much doubt that these officers were searching for evidence. The first thing they did when they entered Mr. Kalin's room was not to look for a bleeding victim, but to examine his clothing, to examine the shoes he had worn the night before. Finally, I think it's important to bear in mind that the whole purpose of the Fourth Amendment is that we don't entrust our privacy to the discretion of police officers who are engaged in the process of ferreting out criminal activity. The purpose of the Fourth Amendment is to have a neutral magistrate intervene between the police officers and the citizen. And here in California, we have magistrates a phone call away. All they had to do was pick up the telephone and they could have gotten a telephonic search warrant. And we were told by the officer, we've never used that procedure. And we might ask ourselves, why? Is it because they don't need to? Is it because conjuring up this exigent circumstances or emergency exception is some sort of talisman that makes the Fourth Amendment disappear? Is it because we don't have the fortitude and the courage to say to our police officers, the Fourth Amendment means what it says? And what it says is, before you invade the privacy of a person's residence, you get probable cause, you go to a judge, and you get a search warrant. Thank you.
All right, is matter submitted at this time? By both sides?
The court is not inviting the people to be heard again, I take it.
No, I'm not at this time.
In that case,
All right, the court will announce its ruling tomorrow morning. We will be in recess at this time until 9 o'clock tomorrow.
I'm going to stop here today, guys. I know I said I was going to do one more, but I have a members only video, and I have exactly enough time to do it right now before the courts open up. And it's really good, and it's a little inappropriate. So I want to get that together. You guys are going to like it. I mean, I don't know if it's as great as the last one, but it's still pretty good. I'm not going to play it right now, or it'll be a live stream. I'm going to get it together. Cut, paste, edit, all that stuff. So, thank you so much for coming out. Thanks for watching The Simpson, OJ Simpson trial. We're going to keep going, guys. We are. We're just going to keep plugging away at it. Thank you. Hey, behave, okay? Bye.